Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to learn a very important issue relating to the charge sheets. The issue is whether charge sheet has to be uploaded into the website just like FIR or not. This is the question. It has been answered by the Honorable Supreme Court of India in the case of Saurav Das versus Union of India in WP number 1126 by 2022, decided on 20th January 2023, that is yesterday, by two judges bench, Honorable Justice M.R. Shah and C.T. Ravikumar, wherein they clearly held that the charge sheet is not a public document as per section 74 of the Indian Evidence Act, and there is no necessity to upload the same on the website just like the FIR. Very clear-cut instructions or orders have been issued in this particular regard. So let us better know as to what happened. Mr. Saurav Das, you all know that he is a very good, I can say, right in the RTA activist and also very political activist also. And this man has filed a petition or public interest litigation, literally, public interest litigation before the Honorable Supreme Court of India to see that the charge sheets by the police, like the ED and also the CBI, both of them very powerful agencies. CBI, which was established under the Special Police Delhi Special Police Establishment Act, and ED, they will be attaching so many properties in so many offences. So, both these and other police, whenever they file the charge sheet, it has to be uploaded because the people should know. Once it is uploaded, it becomes a public document. Once the investigation is completed and charge sheet is filed, charge sheet can be taken as a public document as per Saurav Das. But Supreme Court said, no, it's not like that. Reason. I have to discuss the reason also. Now, coming to the uploading of the so-called investigation part, we all know that as per 154 CRPC, it is the statutory duty of the police to register an FIR. When once an FIR is registered, it has come to the public domain, and that is website. This is what is said in the very famous Young Youth Advocates Association or Youth Bar Association. Yeah, Youth Bar Association, filed by Justice Prashant Bhushan. Yes, so sorry, not Justice, is Advocate Prashant Bhushan. So, in Youth Bar Association, Honorable Supreme Court of India clearly stated that when once the FIR is registered, it has to be uploaded to the website. That means it has to come to the public domain. Whoever is interested, he can take down a copy of the FIR. Likewise, in Andhra Pradesh also, we have got AP Police Seva. In that AP Police Seva, if you type the crime number or so, yes, you can get a copy of the FIR. Of course, you can't get the complainant copy attached to the FIR, but you can get a copy of the FIR. So, this Saurav Das says same thing will apply to the charge sheet also. But no. So, even though Section 6, Clause 2 of the RTA Act says that no reason can be given for filing a document according to RTA Act, but according to Section 8, yes, definitely there are certain limitations. Charge sheet, after complete of investigation, what will have? It will have the names of the witnesses. It will have the array of the accused. It will have the ramifications. It will narrate so many descriptive incidents also. Such things should not be known to the general public. That's why even, so 154 we have discussed, Why? According to 173 CRPC, whenever the investigation is completed, they have to file the final report, maybe in the name of charge sheet or maybe in the name of referring the case as mistake of fact, mistake of law, undetectable, civil nature, NC, non-cognizant, all these things like that. Police are destined to file the charge sheet as per 173 CRPC. So, even in the charge sheet, please remember, the memo of evidence need not be given to the accuser. There itself the clause is there. The memo of evidence need not be supplied to the accused immediately. It can be appended separately. Because why? Because if you give the memo of evidence, what happens? The accused person will be in a position to know what each witness is intending to speak. Therefore, there is a chance of managing them. So therefore, it's not given. So likewise, so please remember, according to section 74 of the Union of India Act, what are public documents? I can say public documents are, number one, definitely the acts of the state and center. They are all definitely public documents. And secondly, the documents which are giving the documents of the sovereign authority. That means like any GO, circulars, memorandums. The documents of official bodies and tribunals like judgments or the so-called testimonials copies, and the documents of public officers, legislative, judicial and executive of any part of India or a foreign country. Documents, yes, it is stamped or it is authorized by, yes, it's a public document. It can be filed. And public records kept in any state of private document. Sometimes they may be kept in the state of private document. You need not bother about. So, charge sheet is not written here. Charge sheet is not a public document. Of course, it becomes a public document when, according to section 76, when it is a public certified copy is obtained. So, that is a different chapter. You have to go to the Indian Evidence Act if you want to know all these things. But anyway, here the main point is, charge sheet is not a public document. Charge sheet need not, more than that, charge sheet need not be uploaded in the website. If you know this much, it is sufficient. With this, I am concluding. Thank you very much.